Before the judge even gets to the sentence, this case is already loaded with drama. A New Year's Day shooting, an innocent bystander hit in the stomach, bullets entering a home with other people inside, and now a courtroom trying to decide how much time Olivia Twenden should serve. The prosecution says there's no remorse. The defense says the court should look at her background, her lack of major criminal history, and the chaos of the moment. But the biggest question is this: when someone's rage changes another person's life forever, how much punishment is enough?
This is State of Ohio versus Olivia Twenden. We're here for sentencing. Mr. Goodyear, are there any statements from the victims?
Judge, yes, I would actually like to speak first, and I'll have them come and speak to you if that's okay.
That's fine.
I want to start by saying that we're asking for restitution for two separate victims in this matter. I think it's part of the pre-sentence investigation, but there's a request for $750 to Pamela Wadsworth for damage that was caused by the defendant when she had the accident you heard testimony about, and then $1,390 to Daniel Johnson. I want to talk about allied offenses. The state concedes that the two felonious assault charges that the defendant was convicted of are allied to the attempted murder charge. So the state is electing to go forward on sentencing on the attempted murder and the firearm specifications that are attended to that charge. And we recognize that the two felonious assaults would merge with the attempted murder. However, Judge, count 4, which is illegal discharge of a firearm into a habitation, I think is not an allied offense. If there is a separate identifiable harm by each count, then there are not allied offenses. And I think you recall, Judge, from the testimony that the victim obviously was shot in the abdomen. A bullet that entered his body and never exited. The fact that there was another bullet that caused damage to the door frame entered the home, and that fragment was found inside the house that then was submitted to the lab, and they said that that bullet was fired by the gun found in front of the motor vehicle she was driving. So I think pretty definitively we know that both Mr. Johnson was shot, and separately there was a shot that went into the home where there were 5 other individuals, as you recall. Improper discharge of a firearm into a habitation is an offense that has a separate identifiable harm from the attempted murder, and therefore they're not allied offenses. So I don't think there's any doubt, and I don't think the court would say there's any doubt that he suffered serious physical harm, serious injury. And then the second question is, well, we have a defendant who has no real substantial prior criminal history, but we have a very, very serious case. And so where does that sentence lie? How should the court balance those things? From my experience, not only dealing with this case, but having listened to both the jail calls and the home wave calls that she's been engaged in, the defendant has since the time she was convicted, she has absolutely zero remorse for this offense. I can say I don't know that I've ever heard someone with less remorse than she has for this offense. I want to play one for you, which I think sums up her attitude.
This is where the prosecutor starts building the emotional core of the sentencing argument. Legally, he's doing two things at once. First, he's asking for restitution, $750 for Pamela Wadsworth and $1,390 for Daniel Johnson. That's the financial side, paying victims back for damage and harm connected to the offense. But then he pivots into something much bigger: allied offenses. In plain English, allied offenses are charges that may merge at sentencing because they punish the same conduct. The state agrees the felonious assault counts merge into attempted murder, but argues the shot into the home created a separate harm. And now, to drive home the point about remorse, the prosecutor is about to play a call. Listen closely, because this is the moment the tone of the hearing changes.
And I think, frankly, is indicative of the way she views this case in total. This is going to be her and her mom talking about the reaction to the verdict.
Your buddy said he's been on Facebook and nobody's posted anything. Not yet.
I just can't believe, how nobody was thrilled when this is what they wanted.
I really thought they'd be hugging and laughing, well, not laughing, but hugging and basically celebrating this, but they weren't. They weren't. His mom, his grandma, and especially not Daniel.
Yeah.
Yeah, he was crying.
Yeah.
I mean, you're running a young girl's life. How could you not be upset?
That phone call is devastating for the defense. Instead of centering the man who was shot, the conversation frames the verdict as ruining a young girl's life. And look, sentencing is not just about what happened during the crime. Judges also look at accountability, remorse, risk to the public, and whether the defendant understands the damage caused. The prosecutor is using this call to argue that Olivia sees herself as the victim of the conviction rather than Daniel as the victim of the shooting. That is a major problem at sentencing. So here's the question for the audience: is this just a family reacting emotionally to a guilty verdict, or does it reveal something deeper about lack of remorse?
Ruining a young girl's life, how could you not be upset? That's her reaction to the verdict. She sat here and listened to Daniel Johnson testify, listened to her mother. She knows what she did, and her response to all of that is that the victim, because he participated in the prosecution in this case, is ruining a young girl's life. And I'll tell you, Judge, I've listened to almost all the calls she's made since sentencing, and that attitude is the attitude she's had throughout the entire process. Depending on how you calculate this, the minimum sentence that she faces is either 11 or 14 years, depending on the way you look at the specifications. And I would just say, Judge, I would argue to you that for the defendant to receive a minimum sentence in this case would demean the seriousness of the case. I think that a sentence of 11 or 14 years would not be appropriate knowing the nature of the case we have. I don't think I've ever heard someone care as little as she does about what she did. So, Judge, I would ask you now to allow the victims to speak to you as well.
All right, thank you.
Hi, my name is Sharon. Daniel is my grandson, and he's my heart. He's not a perfect person, but he has a good heart. He would never think of hurting somebody else. He used to be a true go-getter. He had good grades throughout school. He played football, and he excelled at it. He has many friends, and I have never met anyone who didn't like him. He used to go to the gym regularly and run miles every other day. But because of one person's rage that she admitted to feeling, nothing is the same, and I don't think it ever will be. His left side hurts constantly. He suffers from severe stomach problems because the bullet that hit his rib exploded and destroyed his intestines. And I mean destroyed. He still has several fragments of that bullet in his body, which will likely cause even more problems as he ages and those begin to move. The saddest part of all of this is that throughout the entire ordeal, she has not shown one bit of remorse or concern for the man she shot instead of the ones that she wanted to shoot. She continues to look at Daniel as if he has something to do with it, as if he would drop charges when it was the state, not Daniel, that brought the charges. Your Honor, I also want to emphasize that she was convicted of attempted murder. That's not just a mistake. That's a deliberate act. And I believe with my whole heart that if she is ever enraged again, as she described it, she will do the same thing again. Please, Your Honor, give her the maximum sentence so she can never harm another person. She may have already given Daniel a life sentence with what she did to him. So there's no amount of time you could give her to actually satisfy me. But I ask you to protect others by ensuring that this doesn't happen again because of her anger. Thank you, Your Honor.
Daniel's grandmother just delivered one of the most powerful points in the entire hearing. This wasn't simply an accident in the way people casually use that word. The jury convicted Olivia of attempted murder, and the family is emphasizing that Daniel is now living with lasting pain, stomach problems, bullet fragments, and emotional trauma. Another key clarification here: Daniel did not personally bring the criminal case. In Ohio, like in most criminal prosecutions, the state brings the charges. Victims can cooperate, testify, and give impact statements, but the case is State of Ohio versus the defendant. That's why the family is so upset by the suggestion that Daniel somehow caused Olivia's legal consequences. Their argument is simple: she fired the gun, he lives with the damage.
Thank you very much.
My name is Misty Johnson, and I'm the mother of Daniel Johnson. I'm writing to share with this court the devastating impact that Olivia's actions on January 1st, 2025 has had on the life of my son, my own life, and my family's life. Before January 1st, 2025, my son was a happy, easygoing, and carefree young man. He was incredibly athletic and dedicated to fitness, lifting weights 3 to 5 times a week, and working out almost every day. He was a person who got along with everyone he met, and it seemed like everywhere we went, someone knew him and greeted him with a smile. He was a vibrant part of our community. Since that day, my son has not been the same person. He was an innocent bystander minding his own business when Olivia, in a fit of rage, decided to try to kill her husband and boyfriend. My son had nothing to do with her conflict, yet he is the one who has suffered the consequences of her violence. Throughout the trial, I have watched her closely. She has shown absolutely no emotion or remorse, even when my son was crying out for his life. The only emotion she displayed was for herself, or her give my son the most hateful look I've ever seen as she walked past him. It was clear that she takes no responsibility for her actions and instead blames him for the prosecution. It is only just that she is held fully accountable for the life she has forever altered. Your Honor, thank you for considering the impact on our lives during your sentencing.
Thank you, ma'am.
Your Honor, my name is Daniel Johnson, and I'm here to give some insight on how this crime has affected my life. On the day of the incident, I was attending a New Year's Day get-together. I had been invited over and was sitting on the porch minding my business. The defendant was attempting to shoot at someone else, and I was the one who ended up being shot. In that moment, my life changed for reasons that had nothing to do with me. Since that day, I've had to live with the physical and emotional damage. I was shot in the stomach. I had multiple surgeries. My recovery has not been simple, and it hasn't ended. I deal with chronic pain on a daily basis, along with ongoing digestive issues that have forced me to completely change how I take care of myself and eat. Mentally and emotionally, I've been dealing with PTSD. What happened that day didn't just end when the incident was over. It has stayed with me. There is a level of stress, fear, and anxiety that I now carry that I didn't before. What makes it especially hard is knowing that I was completely uninvolved. I was simply in the wrong place at the wrong time, and I'm the one who will have to live with the ramifications. Olivia has not shown any level of respect to myself or my family. I have not received an apology in any form or fashion. I do not hate her or have any evil feelings in my heart towards her or anyone associated with her, for that matter. I truly am just sad, and I wish that things were different.
Daniel's statement hits differently because it is controlled, measured, and honestly heartbreaking. He says he was simply sitting on a porch, uninvolved, and became the person who paid the price for someone else's conflict. He talks about surgeries, chronic pain, digestive issues, PTSD, fear, stress, and anxiety, but then says he doesn't hate Olivia. That contrast is powerful. The victim is describing life-changing harm, but without revenge language. And from a sentencing perspective, that matters because victim impact statements are meant to show the court the real-world consequences behind the legal charges. This is no longer just attempted murder on paper. It is a person explaining how one bullet changed his body, his mind, and his future.
And this would have never happened. Thank you, Your Honor.
Thank you, sir.
As it relates to the allied offenses, it is our position that the discharge of a firearm is, in fact, or we would ask Your Honor to find that it is an allied offense of the attempted murder count, in light of the fact that under what the state has presented in their sentencing memorandum in the case law, you are to look at the conduct of the defendant in determining the position on the allied offenses. As it relates to conduct, from what was presented at the trial, there were at least 2 shots that were fired off in quick succession. The conduct as a whole and the fact specifics where there is some type of a heated argument that has occurred and shots that are fired off in quick succession pursuant to State v. Johnson, that all of that taken can mean, of course, that there would be allied offenses. So as it relates to the other victims, certainly the intention was not to harm anybody inside of the home. This was not something where there was a shot and then shortly thereafter, there was a break in another shot that would have hit some surrounding property. Everything happened all in quick succession, all the same course of conduct. And so we would be asking that it be an allied offense. It's easy to cherry pick a call and indicate that there's a lack of remorse. I think what is relevant to Ms. Clendenin is actually what was presented during trial during her interview with the officers. And as soon as she found out that Mr. Johnson was hit, her actual reaction was, "Oh my God, is he okay?" And she was inquiring of the detective as to his status. Now, over time, people can view things differently, the impact that it has on themselves instead of looking outside of themselves. Also, my understanding, though I don't have any jail calls to play for, Your Honor, specifically, that Ms. Clendenin did speak with her family about sorry, not to say sorry, I don't want to put words in their mouth, but feeling a certain way, that it's unfortunate that Mr. Johnson and his family have had to experience this. That is my understanding of some of the conversations, certainly not all of them. Clendenin's mother appeared to be indicating she was expecting somebody to be jumping up and down, joyous and, excited, so to speak. But Ms. Clendenin indicated, well, that's not what they were doing. And here's maybe why they weren't doing that, because this is not only impacting them, but it also impacts me in my life. So again, I don't know that it's appropriate to pick and choose the limited phone calls to not include everything. But of course, that was the state's decision and within their right to do that. I'm by no means trying to say that the serious provocation on his part by any means, but I think the actual intended individuals, according to what was at trial, were the other 2 gentlemen, and there was some inducement or facilitating in terms of bringing upon the offense. So in terms of the mitigating information, Ms. Clendenin, as Your Honor is aware, has remained out on bond during the pendency of this case, which was over a year, without any violations. She was an upstanding member of her community leading up to this. As part of her ownership of the dance studio, she would actually give out scholarships to kids in need. By that, it wasn't something where the studio actually gave money, but she would donate extra time, extra lesson. It's my understanding that Ms. Clendenin, also leading up to this, was attending Northern Kentucky University, so she was trying to improve her life and her standing in life. She'd recently completed a business correspondence course through Harvard University. She held a number of jobs during the course of this case and leading up to it. We again would ask Your Honor to impose a sentence of 8 years as it relates to the firearm specifications, that Your Honor would merge the discharge into a habitation with the attempted murder, and we are asking the court to impose.
Now the defense has a tough job, and this is exactly what defense attorneys are supposed to do at sentencing: argue mitigation. They're asking the judge to merge the discharge into a habitation count with attempted murder by framing the gunshots as one continuous course of conduct. They also push back against the prosecutor's use of selected jail calls, saying it is unfair to cherry-pick the worst moments while ignoring other conversations or Olivia's initial reaction when she learned Daniel had been hit. Then they bring in her background: no bond violations, community involvement, a dance studio, scholarships, school, work history, and efforts to improve herself. The defense is not saying the injury didn't matter. They're arguing the sentence should not be the maximum. The legal battle here is punishment versus mitigation.
It was a minimum sentence at this time. We appreciate the court's time and consideration.
All right, thank you.
Your Honor, I respect this court and where it stands. I would just like to say that I care deeply about my family, my friends, my business, and those who rely on me in this world. I take great pride in the impact that I have had on my community and the children that I coach and that I basically raise them with their parents. And I will continue to do so moving forward. And to Daniel, I am very, very glad that he is well after a difficult time he has been through. And I truly hope.
Olivia's statement is brief, and that brevity is going to stand out. She talks about her family, her business, the children she coached, and her role in the community. Then she addresses Daniel by saying she is glad he is well after a difficult time and wishes him the best. But notice what is missing, at least in the words we hear here, a direct apology. No clear "I'm sorry I shot you." No detailed acknowledgement of his surgeries, chronic pain, or trauma. Now, some defendants are cautious about what they say after conviction because of appeals or legal strategy. But judges are human, and sentencing is a moment where accountability matters. Do you think her statement helped her, or did it confirm the prosecutor's argument about remorse?
That he has a great future, and I wish him nothing but the best in his future. Thank you.
All right, thank you. I've considered the purposes and principles of sentencing, including punishment, deterrence, and protection of the public. The Supreme Court's decision in State v. Beatty, the court finds that it must impose 2 of the firearm specifications, the 5-year drive-by shooting specification and the 3-year firearm specifications. I do not believe that count 4 merges with count 1. The sentence on count 1 is 8 to 12 years to be served after the 5 and 3, and the sentence on count 4 is 2 years, but that will be run concurrent with count 1 for a total of 16 to 18 and a half years. On release, you will be supervised by the Adult Parole Authority for a period of 5 years. If you violate any of the rules of supervision, the Adult Parole Authority can send you back for 9 months per violation, up to 1/2 of your stated sentence, which would be 8 additional years they could add for cumulative violations of post-release control. It is rebuttably presumed that you will be released from service of the sentence after serving the 16 years. The Department of Corrections, however, may rebut the presumption if, at a hearing, the department makes specific determinations regarding your conduct while confined, your rehabilitation, your threat to society. If you've not been released prior to the expiration of the 18 and a half years imposed as a part of the sentence, you must be released upon the expiration of that term.
Judge, can I just interject real quick since you're talking about the indefinite sentence?
Yes.
So the sentence you gave her on the underlying count was 8 to 12?
Correct.
So I believe that 4 years has to be added to the indefinite term. So I believe the actual term is 16 to 20 and a half years.
This sentencing math is important, and it's easy to miss because it happens fast. The judge gives 8 to 12 years on the attempted murder count, plus 2 firearm specifications, a 5-year drive-by shooting specification and a 3-year firearm specification. Those firearm specification terms are served first and are mandatory in the structure the court describes. The judge also gives 2 years on count 4, the illegal discharge into a habitation, but runs that concurrent with count 1, meaning it does not add extra time on top of the attempted murder sentence. Then the prosecutor catches the indefinite sentencing calculation with the 8 to 12 year range and the added firearm specification time. The total becomes 16 to 20 and a half years, not 16 to 18 and a half. That correction matters because it changes the maximum exposure by 2 years.
You're right.
So when you said 18 and a half, it's really 20 and a half.
Yeah. That's all. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
In the end, the court sided with the prosecution on the key sentencing issues. The felonious assault counts merged into the attempted murder count, but the illegal discharge into a habitation did not merge because the court treated it as a separate harm. The judge imposed the firearm specifications, sentenced Olivia on the attempted murder count, ran count for concurrently, and after correction, the total sentence became 16 to 20.5 years, followed by 5 years of post-release control. This case shows how sentencing is about more than the conviction itself. It's about harm, accountability, public safety, remorse, and the lasting impact on victims. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Stay in chat with him for 15 minutes, or you guys need to get her cover. Okay, yep, alright, let's go ahead.